has one word just cost Prince Harry $67 million. And by the way, it's $67 million he don't have because the money is running out. This is the new reporting, interestingly, from a longtime ally of Prince Harry.
The Daily Mail are pursuing Prince Harry for unlimited legal costs, and they're looking for $13.3 million from the claimants up front. And that is just the beginning.
What the Daily Mail is seeking is costs on an indemnity basis. In effect, everything that they've paid for, as far as it's reasonably incurred, would have to be paid for by the claimants. And they're seeking somewhere around about $40 or $50 million. So you can see the difference and the problem and the headache.
He went to that court for relief, saying, help me, this is the place to get help. And then when the court disagreed with him, he attacked the court.
Prince Harry thought this case would expose the newspapers. Instead, it may have exposed something far more damaging. 97 separate allegations, every single one dismissed. A judgment spanning more than 400 pages from a judge who had warned, even before the trial began, that much of the case should never have reached his courtroom. This is the story of how Britain's most expensive privacy lawsuit unraveled. Why Harry's own words after the verdict could end up making an already costly defeat even more expensive, and why the man standing beside him outside the cameras isn't the one expected to pay the final bill.
Their insurance in this case was around about $2.5 million per claimant. So it's fairly limited. So it means that if they lose the case and damages are awarded against them, or the costs are awarded against them higher than the $2.5 million, then they have to stump up from their own pockets. And so if Harry's bill is, say, $10 million, which it may well be in respect of his costs, then clearly there is a large shortfall which he'll have to find.
And by minute 14, you'll see the exact moment Harry's credibility cracked in open court. The moment that cast a shadow over every remaining claim in the case. The lawsuit was supposed to be about the newspapers. Prince Harry and 6 co-claimants, Sir Elton John, Elizabeth Hurley, Sadie Frost, Baroness Doreen Lawrence, and 2 others took Associated Newspapers, publisher of the Daily Mail, to court, alleging that stories published over the past 2 decades had been obtained through unlawful information gathering. The allegations were serious. The people bringing them were high-profile, and leading the case was a member of the royal family. On paper, it looked like the kind of lawsuit that could end with a major settlement or a public reckoning.
And I think they've rather got involved in it's almost starting something and feeling you can't stop. And I think it's a hard task to accept that something's not right and pull out and cut your losses early on, especially when you've got the legal teams that are perhaps giving the advice that, look, everything looks okay. And to some extent, I expect the claimants were rather duped by their investigators and the information they were being given. It made them feel like they had a stronger case than what they actually had.
Harry's legal team believed the evidence was strong, and the other claimants placed their trust in that same confidence. That was the expectation going in. What came out of the courtroom was something very different.
They lost every single claim, but some of the criticisms are quite devastating.
Well, you're so right about that. I'm no legal expert, but it really caught my eye that I believe there were 97 claims against the Daily Mail, all of them dismissed. Normally, it's like a parking ticket. Normally, you'll get done for something, but every single claim was thrown out. That's unusual, isn't it?
97 claims were filed. 97 claims were dismissed. Mr. Justice Nicklin examined 57 articles in detail. Of those, 32 were argued on grounds that differed materially from the way the case had originally been presented, and another 24, in the judge's own findings, were not supported by sufficient evidence.
My understanding is Daily Mail was not going to settle with them because they understood that they were going to win the case, or they believed that the odds were, substantially stacked in the outlet's favor. So I don't know if there was an opportunity to settle for any dollars. It would have just been a walk away, and they decided to go forward, and they rolled the dice, and it came up against them, and now it's time to pay the bill.
In the end, not a single claim succeeded. That isn't what a case looks like when it loses because of a technicality. It's what a case looks like when the court concludes it was fundamentally unable to prove what it set out to prove.
But 32 were materially different than the case when it was first advanced. So things were changing. There was an argument put forward, an allegation put forward, a claim put forward. And as that developed, and once it reaches court, 32 arguments had changed. They were just completely different. And 24 of the articles and the arguments, the allegations were without proper evidence, according to the judge.
The judge had signaled those concerns before the trial even began. He warned that the case faced serious problems long before the evidence was heard. During the proceedings, the claimant's own principal witness changed key parts of his testimony, stepping back from statements he had previously made. And throughout the judgment, Mr. Justice Nicklin made one point unmistakably clear. Suspicion, even if sincerely held, is not evidence. In court, allegations alone are never enough.
The ruling, it's over 400 pages and is blistering. And he was warned the case should have never proceeded to court. Their main witness had done a 180-degree turn. And so I do struggle to understand what the thinking was of the claimants after all of that information was developed.
They kept going anyway. And the first real crack in the case didn't come from a newly discovered document or a surprise piece of evidence. It came from someone who had once been part of Harry's own circle. Charlotte Griffiths, now editor-at-large of the Mail on Sunday, took the witness stand. More than 2 decades earlier, she had known Harry personally as a young journalist. Harry's account under cross-examination was straightforward. He said that once he discovered Griffiths was a journalist, he ended the friendship to protect his privacy. It was presented as the natural reaction of a young royal becoming more cautious about the press. Then Griffiths gave her evidence, and the courtroom heard a very different version of events.
Part of the trial, it related to Charlotte Griffiths, who's a good friend of mine. She's the editor-at-large of the Mail on Sunday. You know her well. And she went into court, and it was the position of the claimants and of Harry that he discovered that Charlotte Griffiths at the time, a couple of decades ago, was a journalist and cut off contact with her. Well, she's in the witness stand, and she says that's not the case. We had quite a protracted friendship in which her nickname for him was Mr. Mischief, and he spoke to her about movie snuggles. There was definitely a friendship there, if not more. Harry's position is, I didn't know who she was, found out she was a journalist, cut her off. Charlotte Griffiths then goes on to tell the court that it was she that cut off the prince following their various exchanges.
Her testimony didn't match Harry's account. She described a friendship that was neither brief nor one-sided. According to her, they shared a genuine friendship, complete with the nickname Mr. Mischief, and personal conversations that, in her view, reflected the kind of trust you place in a friend, not someone you had just discovered was a journalist. She also told the court that it wasn't Harry who ended the friendship. She said she was the one who walked away. That was the sworn evidence the judge heard from the person on the other side of the very story Harry had just described.
It just discredits him as a person and him as a character, as a human being, as to what he's trying to achieve from all of this. It's just got so messy that it's damaged the case. There's so many bits that have come out of this. It's hard to know what the connection is, how it's going to help his claim.
That exchange proved difficult to overcome. And then the court was shown another inconsistency. During cross-examination, Harry told the court he had never attended a particular festival. In response, counsel for the defense reached for a copy of Spare, Harry's own memoir. Inside it was an account written by Harry himself, describing his attendance at that very festival. The courtroom was no longer comparing Harry's evidence with someone else's memory. It was comparing his testimony with his own published words.
Harry said that he'd never been to a festival, I think it was, and the counsel working on behalf of the Daily Mail said, well, you wrote about going to a festival in your book Spare.
2 inconsistencies surfaced in the same trial, only moments apart. Neither relied on anonymous sources. Neither was based on speculation. One came from a named witness giving sworn evidence in court. The other came directly from Harry's own memoir. Think about that for a moment. The court wasn't comparing his testimony with rumors or newspaper reports. It was comparing what Harry said under oath with what Harry himself had already published in Spare. That became one of the most closely watched moments of the entire case.
Their main witness had done a 180-degree turn. And so I do struggle to understand what the thinking was of the claimants after all of that information was developed, that they think that they could have succeeded.
By the time the judgment was handed down, the collapse of all 97 claims was no longer difficult to understand. The problem wasn't a last-minute technicality. It was that the evidence the court required was never there. And when the judge had the opportunity to weigh Harry's account against the evidence presented by others, Harry's version was not accepted. For most people, that would have been the moment to step back, say nothing, and let the judgment speak for itself. The judgment had been delivered.
It was probably a mistake on this occasion, but it didn't see it as a mistake at that time. With hindsight, it's a great thing. You can look back and say, yes, I shouldn't have done that. It just wasn't good enough. The case wasn't strong enough. There's no doubt that Prince Harry and the claimants all believed that they had the right to claim, and they had grievances. I don't think there's any doubt about that. The problem they had is the evidence was just not good enough to prove that the associated newspapers were the people responsible for that. And that's where it's fell apart.
For many, that would have been the end of the story. Instead, it marked the beginning of another. Shortly after the ruling, Prince Harry and Baroness Doreen Lawrence released a joint statement describing the decision as a complete and obvious whitewash. It was a striking response, not only because they rejected the outcome, but because it publicly challenged a judgment that had just been handed down by the court.
First, I just want to read you out this reporting from Dan Wakeford and his Celebrity Intelligence. It's interesting, of course, because for such a long time, as you know, he was very much Team Harry and Meghan. But now he writes, 2 weeks from now, Mr. Justice Nicklin sits down again, this time to decide who pays for the most expensive privacy trial in British legal history. And the man he's deciding it for is the same one who just called his verdict a whitewash. Prince Harry and 6 fellow claimants, including Elton John and Liz Hurley, lost every one of the 97 allegations they brought against associated newspapers.
The judgment had already been handed down, but the response wasn't spontaneous. It wasn't a comment made in the emotion of the moment outside the courthouse. The statement had been prepared in advance, reportedly drafted before the ruling was made public, reviewed, finalized, and then released. Only 2 names appeared beneath it, Prince Harry and Baroness Doreen Lawrence. Yet, there had been 7 claimants in the case. The other 5 chose not to sign, and one omission stood out more than any other. Sir Elton John, one of the most prominent claimants, did not put his name on that.
Doubly so when the language reads as an attack on the judiciary itself, rather than just an adverse result. English costs rules explicitly bake conduct into the calculation. Under Civil Procedure Rule 44.2, judges can move a losing party onto indemnity costs, a tougher standard, where the burden flips onto the loser to prove the bill was unreasonable if their conduct falls out of the norm. There's precedent for exactly this kind of attack costing real money. In one case, a litigant who made baseless claims that a court officer had acted dishonestly was hit with an indemnity cost order worth roughly £80,000.
Sir Elton John was no stranger to litigation in the British courts. He had been through these kinds of legal battles before. He understood how cost hearings work and what—
This was not an off-the-cuff, angry statement. You know, they knew about the verdict beforehand. And also, frankly, I don't think Harry's smart enough to come up with an off-the-cuff statement. So this statement was prepared at least a day in advance. And what was interesting about it, it was only Baroness Lawrence and Harry on it. Elton John, who knows quite well how the courts work, didn't sign it.
He had the opportunity to support that statement. He saw the wording, and he chose not to sign it. Whatever Harry's team believed the whitewash claim would achieve in the court of public opinion, the most experienced litigant among the claimants decided not to attach his name to it.
You know, they knew about the verdict beforehand. And also, frankly, I don't think Harry's smart enough to come up with an off-the-cuff statement. So this statement was prepared at least a day in advance. And what was interesting about it, it was only Baroness Lawrence and Harry on it. Elton John, who knows quite well how the courts work, didn't sign it.
Because the case wasn't over yet. A cost hearing was still ahead.
Prince Harry comes out, says it's a whitewash, casts aspersions on the judge and the way the case has been handled. It's not a sensible approach for him to do. I think even the other claimants have tried to move against that decision and say, well, look, that was him. Part of the arguments that we're now seeing in court today, probably see tomorrow, is that some of the claimants are saying, well, look, this shouldn't affect the other claimants.
The Daily Mail's publisher wasn't satisfied with simply winning the case. It wanted its legal costs back. So, it applied for costs on what's known in English law as an indemnity basis, the higher standard, one that can shift more of the financial burden onto the losing side, and potentially push the bill far beyond the ordinary level. Under Civil Procedure Rule 44.2, when deciding costs, the court doesn't look only at who won and who lost.
Now, in the English system, unlike the U.S., they have a loser pay system. So, when somebody wins the court case, the loser is generally going to have to pay court costs to the winner. And that's a very fine system because it dissuades unmeritorious litigation, and it helps the winner recover the costs that they should have never had to pay to begin with to be hauled into court.
It can also consider how the losing party conducted the litigation, including what they said and did after the judgment was delivered. Harry had already lost. Then, within hours of the ruling, he publicly described the judgment as a complete and obvious whitewash. That mattered because the legal battle wasn't over. A cost hearing was still ahead. It was scheduled for July 29th and 30th. The judge hearing it was Mr. Justice Nicklin, the very same Judge Harry had just publicly accused of delivering a whitewash. The same judge who would now decide whether the claimant should pay costs on the standard basis, with Associated Newspapers' recoverable costs provisionally capped at around £4 million, or on the far more expensive indemnity basis, potentially allowing the publisher to pursue a substantially higher amount from the unsuccessful claimants. Two lawyers interviewed independently reached almost exactly the same conclusion. London solicitor Marcus Stone called the statement intemperate. California attorney Christopher Melcher described it as insolent. Neither appeared to know what the other had said. Neither needed to. They reached the same conclusion because, from a legal perspective, the point was straightforward. Publicly attacking the judge who is about to decide how much you may have to pay is not a legal strategy.
Two people who released the statement, Paula, are the two people I would argue who don't live in the real world, because everyone else is worried about, well, is this going to result in me being bankrupt? Sure, they have relied on very nefarious people, proven criminals, who say, oh, don't worry, we've got all of this money from the dead Max Mosley. That's going to cover all of this. Maybe it will, maybe it won't.
It's what can happen when emotion overtakes legal advice.
He's made this court case, which, okay, it's his right to file a court case, and he loses and he pays the consequences or suffers the consequences of that. But then to give the statement thereafter criticizing the court, this is not an honorable thing to do.
There was also a legal precedent that made the situation more sensitive. In one English civil case, a litigant who accused a court officer of dishonesty was later ordered to pay indemnity costs of around £80,000 because of that accusation. Harry's case was not identical. In that earlier matter, the conduct took place during the litigation itself. Harry's statement came after the judgment had been handed down. Whether Mr. Justice Nicklin would take that into account at the July 29th cost hearing remained an open question. What was much harder to argue, however, was that the statement helped Harry's position. The insurance was never going to cover all of this.
The insurance company is likely, if they haven't already, alerted the team they're not going to pay, or they're going to fight having to pay because, first of all, the case should never have been brought, as Justice Nicklin warned, and then in his judgment said there was absolutely no evidence. Second of all, the way that Harry acted in court and frankly lied in court. And I think the insurers will say, no, we don't have to pay. This was all in bad faith. So they could be on the hook for even more.
Paula, and according to current reporting, Elton John is not stepping in to cover the bill.
So you have a conceivable scenario where all of the money from the book Spare could disappear as a result of this wild mistake.
That's right. And it's even worse than that, Mark, because the claimants are also jointly responsible for the common parts of the claim as well as severally liable. So one claimant may have to pay the costs of all the other claimants. So they're all responsible for their claim. They will all be assessed individually as part of their individual claims. So they're individually responsible for that. But the common parts of the claim, so where they're all agreement about what their common claim is, then each one is responsible for the other's costs as well.
The claimants had collectively taken out litigation insurance, reportedly worth between $15 million and $20 million, to protect themselves if they lost. But if the final cost bill reached anything close to £50 million, that protection would be exhausted almost immediately. And there was another problem. Litigation insurance is a contract. If a claim was pursued on information that was not fully accurate, or if concerns about the credibility of a key witness were known but not disclosed to the insurers could challenge the policy or even refuse to pay. That is no longer a hypothetical question. It is now a live issue.
I expect she rather regrets joining the action. But it is a difficult situation. When you've got people with money, with influence, with power, celebrity, and they believe they've got the chance of winning something, then they can't say no. It's something they just get stuck into and they can't stop. It's a strange situation, but maybe that's just the mentality of the way they are. That's why they've been successful in their own right in so many things, because they are so pig-headed, because they will stick to something.
And then there is the question of joint liability, the issue that may matter most for Harry's legal team. In a case like this, the claimants can be jointly and severally liable for the shared cost of the litigation. That means if one claimant cannot pay their share, the others may be asked to cover it instead. Not everyone involved is in a position to write a check for a liability running into tens of millions of pounds. Elizabeth Hurley is unlikely to absorb a share of a £50 million bill. Sadie Frost is not expected to either. Baroness Lawrence had previously been told by Harry's own legal team that her costs would be covered.
One of the biggest stresses in the marriage within Harry and Meghan at the moment is the financial pressure, Paula.
In practical terms, that leaves only two claimants who are widely believed to have the financial resources to settle a bill of that size: Sir Elton John and Prince Harry.
He is still going to be challenging the UK government over his security. Remember, a decision which was decided in the King's Court, and Prince Harry lost. What's interesting is that Andy Burnham's appointment of Shabana Mahmood as the UK Home Secretary, it was a reappointment, is very, very bad news for Harry, because the Home Office are furious with the way that he has tried to use this trip and this meeting with the King and the children to force the Home Office into a change of policy.
Not your ATM. That was the reported response to a request Harry is said to have already made. If accurately reported, it reflected more than a disagreement over money. It sounded like one man who had already been through costly legal battles, telling another that this time he would have to pay his own way.
Just watching him with the other matter that you mentioned, his reaction after the case against the Daily Mail was thrown out in language stronger than any judge would normally use, and he's indulgent, and unfortunately he's not very bright.
If you think that's where the story ends, what happened next changed the picture completely. Everything up to this point was only the beginning. The verdict had been delivered. The whitewash statement had already been released. The cost hearing was fast approaching, and in the middle of all of that, Harry boarded a plane for London to see his father. It was presented as the start of a reconciliation. King Charles had agreed to meet. Meghan remained in California while Archie and I accompanied Harry. Reports described it as an emotional meeting between an aging father and a son trying to repair old wounds. The kind of opportunity a family under this much public strain rarely gets twice. Palace sources described it as a positive step. Harry's team also portrayed it as a step forward. The message seemed clear. This was supposed to be the moment the conflict finally began to ease. And then Harry's team briefed the Daily Mirror.
This is Prince Harry speaking on the record about this to the Daily Mirror. Listen carefully. The Duke continues to make the case that he and his family face an enduring security risk by virtue of the circumstances of his birth and his membership of the royal family. The threats that existed while he was a working member of the institution did not simply vanish when he stepped back from official duty 6 years ago. They remain, and the most recent threat assessment underscores the continuing nature of those risks.
While the reconciliation story was dominating the headlines, Harry's team was sending a very different message. Harry himself told the Daily Mirror that the security dispute was far from over. He said he intended to continue challenging the UK government over taxpayer-funded protection. He also pointed to a report from his private security company claiming he remained a terrorism target and argued that his family faced an ongoing risk because of what he called the circumstances of his birth. In the same interview, he linked a claim on the state with a claim tied to the royal family. Both arguments were pushed through the media.
He is the one who made these outrageous allegations that were proven to be false. And then, like everything else in his life, just saying like, well, I'm just going to walk away and let somebody else pick up the tab. Yep. I think this is the time for him to pay the bill. And otherwise, there's just no consequence here.
Both were advanced during what was supposed to be a private family visit, and both landed on the desk of a Home Secretary who, according to reports, was in no mood to be accommodating. Yvette Cooper had remained in the role following the reshuffle, and reports suggested her department was deeply frustrated because Harry's team was said to have publicized the visit's itinerary in an effort to increase pressure over the security dispute. He arrived in London for reconciliation, but he also arrived with another legal fight.
As I say, the only way you could possibly have him back in the country would be if his royal status was formally renounced. It has to be. And of course, the royal status of his children, with the security now, the succession, makes absolutely no difference. I think probably the best thing would be if the entire family retired into a form of private life. But of course, he wouldn't do that, would he?
No, he wouldn't.
He loves the attention. He's an attention seeker.
David Starkey watched everything unfold, and then said what few people connected to the palace would ever say publicly. He argued that Harry's actions had repeatedly shown he could no longer be trusted.
I mean, his attempts in returning in public life and enforcing his role in public life result in repeated humiliation. I mean, the scenes, as I said, in the courtroom, his behavior afterwards, and he piled shame on shame that he was publicly humiliated by the judge's remarks.
He went further, saying Harry should not be allowed to return to royal life in Britain unless he formally gave up his royal status. Starkey also compared Harry's situation to that of Prince Andrew and the Duke of Windsor, and said King Charles was showing weakness by continuing to make concessions. Those were not anonymous tabloid claims or palace briefings. They were the public views of a constitutional historian speaking openly on the record.
And do you really believe that there are just the funds sitting there? Because if there really were, why would Prince Harry, according to your reporting, have asked for more money from Elton John, who reminded him, well, no, I'm actually not your ATM?
And this is where all three
stories come together. His testimony was challenged, and he blamed the judge. The judge then moved on to the cost hearing, and Harry publicly attacked the court. His father agreed to meet him. Yet the visit became part of another public fight over security. At each stage, when there seemed to be an opportunity to draw a line under the dispute, the conflict only grew larger. California attorney Christopher Melcher viewed the pattern as something more than a series of isolated decisions. He described it as a failure to understand how one's actions affect other people. It wasn't framed as an insult. It was his professional assessment based on the kind of behavior he has seen from clients before.
So to me, this is...
Does not help the reunion.
No, to me, this is just his insolence and failure to take accountability, failure to understand how he fits in with the world and how his actions impact others. I think it's childlike.
Here's a version trimmed to about 300 words while keeping the main arguments and flow intact. Elton John appeared to reach that conclusion as well. That is why he reportedly chose not to sign the statement. That is also why he is not expected to cover the bill. As of publication, the final cost order had not been issued. The exact amount will be decided by the judge, but the possible range is already public, from the court's £4 million pretrial cap to the Daily Mail's reported claim of around £50 million. Part of that decision could depend on the conduct of the losing side. Yet, after the verdict, Harry continued criticizing the government publicly. So
if they did decide to go after Prince Harry, for example, because he's been trying to cause particular problems for Associated and his comments after the event, then they may say, right, well, we want it all from you. And never mind that the others can't pay. We want you to pay their costs as well now.
Now, what could have been a quiet legal defeat instead became another public battle. Harry can still appeal, but he cannot take back what he said about the judge. He can try to rebuild his relationship with Elton John, but he cannot make Elton sign a statement he reportedly refused to sign. He can tell King Charles the conflict is over, but he cannot undo the media briefings that accompanied the visit. One by one, the opportunities that once seemed open have become much harder to recover. Legal commentator Marcus Stone offered one of the clearest assessments. He argued the case was not strong enough. The evidence fell short, and the legal team should have recognized those weaknesses much earlier. California attorney Christopher Melcher reached a similar conclusion, pointing to a lack of accountability. 2 lawyers, 2 continents, 1 conclusion. Historian David Starkey went even further, arguing that the only long-term solution would be for Harry to formally renounce his royal status. Whether that happens or not, the bigger question is no longer the size of the legal bill. It is which of the 3 battles Harry opened this month will end first. The verdict is over. The cost hearing is next. The security dispute continues. So, what do you think Elton John understood that Harry did not? Let us know in the comments. And don't miss the next video where we'll break down the final cost ruling and what it could mean for the other claimant.